Hey everybody, how are you? Okay, a lot of stuff going on today, but Scott Peterson was denied a new trial by the judge. Now, he can still do something. It's if you go to his, well, maybe we should go to the judge's decision first. Let's see what that, and then we'll go into what his appeal is saying, okay? So I want to go to the actual tweets from today.
Hit the light, guys.
Okay. Let me go over here. Scott Peterson. He cannot appeal this judge's decision, but he can file a new habeas corpus. So I'm going to tell you about that. I'm going to tell you what they're saying. They're like, don't get discouraged on the appeal page, right? But let's go over here. So Scott will not be granted a new trial in the 2002 murder of his pregnant wife, Lacey, in a 55-page decision. The San Mateo County Superior Court judge denied Scott Peterson's bid for a new trial. He's going to remain in jail to serve life in prison without the possibility of parole. So that must be great news for her family, especially around this really sad, Christmas Eve is forever changed for them. But that, just think about how horrible it would be for them to find out he's got a new trial right around this time. So let me see if they have her any of this from in here. Let's see.
It would have been nice for the judge to wait till Christmas Eve and say, yeah, how's it feel, Scott?
Mm-hmm.
You're not getting out
But at
ever.
least if they let the family know privately. But yeah,
Oh,
because I hate that,
yeah.
because I'm sure they're like
Oh, it's
waiting,
horrible.
waiting, waiting. So he's 50 years old now, and I'm going to tell you what their appeal is saying. That it's not. Don't be discouraged. They, they're. Let me go to them. Hang on. Scott. Here's. Okay. So they said Scott Peterson has been denied relief. Judge Masulo found that there was no prejudicial misconduct by juror number 7, which is Strawberry Shortcake, also known as Strawberry Shortcake, Rochelle Neese. The 55-page ruling is available on the San Mateo Court website, and I'll look at that in 1 second. Now, here's what they said. This is from their appeal bid. So, Jamie, his sister-in-law. Scott cannot appeal Judge Masulo's ruling. However, he has other options. The next step is for Scott to file a new habeas petition in California. He can either file in the courts of appeal or with the California Supreme Court, but he must do so within 120 days. The new petition will outline new evidence claims that have come about since his last petition was filed in November of 2015. Scott is going to remain at Mule Creek State Prison as the appeal process continues. And then they say, do not be discouraged. We have active leads. We are actively investigating. We will solve this crime and Scott will be freed. Okay. We couldn't continue in this fight without your prayers and support. And they thank God for them. So, let's see here. Now, people are, absolutely heartbreaking. All these people that are looking for the appeal.
Boo-hoo.
Now, prior
It was her
to that,
appeal.
what, Sharon?
I said, oh, boo-hoo. What was her
Oh.
appeal? Yeah.
Yeah. Prior to that, something came out from the in the Modesto Bee from the former from the original prosecutor, and saying that Scott Peterson won't get a new trial. And they posted the article and said, here is a Modesto Bee opinion piece on the upcoming ruling. It contains the shocking revelation that both the DA and Garth Stapley believe juror Rochelle Neese. We don't have a copy of the transcripts. We'd have to pay for them, but we're curious how many times Rochelle Neese said she couldn't remember or nope when she testified about the improperly filled out juror questionnaire. If Scott isn't granted relief based on prejudicial juror misconduct, then the California courts might as well throw out every jury questionnaire, because juror misconduct can simply be defeated by the words, I don't remember. That's, again, coming from Scott's side, okay? It's grain of salt stuff. Now let me get the judge's decision. Hang on. See if they put it on their site yet. Oh, they didn't move that. All right, let me go over here. Okay. All right. Let's see. This is Scott Peterson. Okay. Is this the one? Let me see here. Okay. Ends in hearings. Updated December 14th. We got that one already. And hold on a second. I'm sorry, I'm just trying to get to this. Let's see here. 2022. Information. The presiding judge issued the standing orders, allow remote access. Okay, what that means. Go to the portal. To access the portal, start here, accept the disclaimer, select. Okay. Accept. Odyssey portals. Be nice if they would leave the directions. See, that's what we need. Please read this. Please click here. Okay. All right, so Scott Peterson, which one is it here? Yeah. Here we go, Scott Lee case. It's funny how they all have, so many of them have the middle name. I know Lee is a common name, but we've got Scott Lee, Christopher Lee. All right, it's loading this up. So I don't know if I'm going to check. I asked Jen before if she got back to see if that car was still there. And let me see if she answered me while I'm here. Come on. Oh, she's answering me about something. Hold on, let me see what she said. Okay, what is this? I don't want to change my messaging right now. Okay. Let's see. Jen. She said, the news was all over there this morning. I will head here shortly in hopes it's not so busy. So the yellow parking pass I took the film of, someone sent me. It is a Lakewood Suites in Moscow, Idaho, the Lakita Inn. Oh my gosh.
Are you serious right
That's
now?
what she said. She said there's also a Candlewood Suites in Idaho.
What?
But what was the date on the parking pass?
Wow.
That's crazy if that's true. That is crazy. Hi, Ann Pulley. How are you? Hi, everybody. Hi, Julie W. Sorry, we're all over the place. It's just been a crazy morning. But yeah, I don't know. That's really weird. Let me see. Let me just message her real quick.
Can you say that again? So
Okay. I mean, she just sent it to me. That is so weird. She said that, so that yellow parking pass that she took in the video last night, remember I was asking her about the parking pass? She said someone sent her that there's a Lakewood Suites in Moscow, Idaho, Lakita Inn, and there's also a Candlewood Suites in Idaho. So is that pass connected to that is what they're trying to say, but is that true? And when was it from? But it's really weird if that would connect that to Moscow, Idaho. I don't know. Very strange. Very strange. Very strange.
what would be the significance of that?
Because what if that car was in Moscow at the time of the murders?
Oh.
Okay. I'm trying to hide this stuff here. Okay, can you please just give me the link here to this? Okay, I've got it now. Sorry. All right, so this is the judge's decision. Scott Peterson was convicted of murdering his wife and unborn child after a jury trial. He claims a petition for the writ of habeas corpus that he was deprived of his constitutional right to a fair and impartial jury because of a trial juror's alleged concealment of bias. Okay, we know all that. The juror was identified. Let's see. Let's go to procedural history. In April of 2003, he was charged with the December 2002 murders of his wife Lacey Peterson and their unborn child Connor. Okay, then a 5-month jury trial began on June 1st of 2004. The jury began deliberations on November 3rd, 2004. Look how long that trial was. The jury continued deliberation until noon on November 9th, when the first of 2 jurors were dismissed. The juror was replaced by an alternate juror number 2. The juror was ultimately became juror number 7, and whose questionnaire was the subject of the petitioner's habeas claim. Juror number 7 ultimately deliberated in both the guilt and penalty phases of the trial. And after another juror was dismissed and replaced, deliberations resumed and continued until November 12th, when the jury found the petitioner, guilty of first-degree murder and guilty of the lesser-included offense of second-degree murder. The jury found the multiple murder special circumstance true. During the penalty phase, the jury returned a death verdict, and the petitioner was sentenced to death. Petitioner appealed the jury verdict and the death sentence to California Supreme Court. While his direct appeal was pending, petitioner filed the instant petition. On August 24th of 2020, the California Supreme Court unanimously affirmed the petitioner's conviction, but reversed his death sentence. The case was remanded to the Superior Court for further proceedings related to both the death penalty and the petition. On May 28th of 2001, the district attorney informed the court that it would no longer seek the death penalty. And on December 8th of 2021, the court resentenced the petitioner to life in prison without the possibility of parole, leaving the petition pending for further proceedings. On the petition, the respondent filed a return and petitioner filed a denial because respondent's return contained a new documentation regarding juror number 7, of which petitioner was previously unaware. The denial included additional factual allegations related to the juror misconduct claim, a supplemental return and supplemental denial followed. Okay. So after reviewing the returns and denials, the court scheduled an evidentiary hearing on February 25th, 28th, and March 1st of 2022. Testimony resumed on March 24th and concluded March 25th of 2022. The parties filed post-evidentiary briefs, and an oral argument was held on August 11th of 2022. The matter was then taken under submission on September 16th, 2022, following the submission of proposed memorandums of decision by both sides. So petitioner claims, concerns, statements. Okay, so they're upset. We know this one because that she felt she was an abused woman and she had a protection order and she didn't release any of that, and they consider a protection order a lawsuit. So yeah, it was all about strawberry shortcake, and they thought that she got on the jury to fry Scott, all of that stuff, right? We've been over that ad nauseum. And let's go to the judge, what the judge says here. So according to juror number 7, she was in the hospital having her 4th child when the alleged violation occurred. During her hospitalization, there was a video taken which showed Ms. Kinsley at Mr. Whiteside's mother's house holding her 3rd child. They were having a party, and she was on video holding my son. Juror number 7 testimony about what she did after she saw the video was unclear. She testified that she learned about Ms. Kinsey being near her son after she was out of the hospital. After seeing the video, she reached out to an East Palo Alto police officer. She testified she wanted to say it was an East Palo Alto police officer, but she was not 100% sure. She then testified that the person she contacted might have been a detective who was kind of a family friendly. She testified she did not remember another incident when Ms. Kinsley violated the restraining order. Juror number 7 was asked if she believed Ms. Kinsley's act in holding her son, who was also covered by the December 13, 2000 restraining order after the hearing, was a crime. So she had the restraining order against this ex of her husband's. And so they went over all this. I mean, I can put the link to this. You can read all this. And I wanted to get to findings of fact. The court finds that several of the answers provided by juror number 7 on her jury questionnaire were false in certain respects. This shifts the burden to respondent to demonstrate that she was not biased against the petitioner. The court finds the respondent has sustained its burden. The court concludes that juror number 7's responses were not motivated by pre-existing or improper bias against the petitioner. So it's not that she wanted to get on the jury to fry Scott, is what she's saying, but instead were the result of a combination of good faith misunderstanding of the questions and sloppiness in answering. So she didn't have any ill motives. She didn't want to just get there to fry him. She just didn't understand the questions, or she was being sloppy in her answering. The court's findings are based on the evidence in the record, including an assessment of the credibility of juror number 7 and the other witnesses pursuant to the factors recited above. And then, let's see, juror number 7's answers to questions 54A and 54B were false. Read together, questions 54A and 54B were asking juror number 7 if she had ever been involved in a lawsuit, and if so, as the plaintiff, the defendant, or both, respondent contends petitioner did not demonstrate that juror number 7's failure to list her petition for a restraining order was misconduct because juror number 7 did not understand that the request and hearing for a restraining order was a lawsuit because it was not a suit for money or property. The court disagrees. With respect to question 54B, it is clear from her testimony that juror number 7 identified herself as a plaintiff. When she filled out the form for the restraining order, she testified that she understood what was meant by plaintiff and defendant in the petition and explained that she was the plaintiff because she was the person asking for the restraining order. In the petition for the restraining order, the word plaintiff appears at least 10 times. In addition, juror number 7 testified that she did, in fact, seek money damages from Ms. Kinsey in another proceeding after the restraining order. That proceeding was in the Santa Clara Superior Court. While the records of that proceeding are not available and not part of this record, juror number 7's testimony was clear. It was a lawsuit for money. Therefore, the court finds that juror number 7's answers to 54A and 54B were incorrect. There is a meaningful argument that incorrect in the context of this case does not mean false, because the questions at issue require the interpretation of legal terminology, and juror number 7 was an unsophisticated layperson. Although the court credits the argument, it finds that it is better addressed in the context of whether juror number 7 was motivated by bias in giving her answer. Accordingly, the court concludes that the legal incorrect answer provided by juror number 7 was false, and the burden will shift to the respondent. Okay, let's see. Now, juror number 7's answer to question 74 was false. The second issue presented concerns juror number 7's response to question 74. Have you or any member of your family or close friends ever been the victim or witness to any crime? The court finds that juror number 7's response to question 74 was also false for several reasons. First, juror number 7 testified that she heard Ms. Kinsey stand outside her home yelling for her and Mr. Whiteside to come outside so they could fight, and then kicked in juror number 7's front door. Juror number 7 also knew that Mr. Whiteside had been a victim of Ms. Kinsey's behavior that day when she slashed the tires of his car and tried to spray him with mace. Juror number 7 admitted on the stand that she considered kicking in the front door and slashing of Mr. Whiteside's tires to be crimes. When asked why she called the police that day, juror number 7 conceded that it was because she thought a crime was being committed. Second, juror number 7 saw Ms. Kinsey following her in a car and testified that Ms. Kinsey was showing a history of being stalkerish. Again, when asked by petitioner whether she considered Ms. Kinsey stalking her to be a crime, juror number 7 answered, sure. Third, while juror number 7 testified that Mr. Whiteside did not assault her during the incident in her home in 2001 of November, she admitted that she hit him, consequently admitting that Mr. Whiteside had been a victim of her assault. Similar to the previous questions, whether juror number 7 had been the victim or witness of a crime raises issues regarding the interpretation of terms that have particular legal meanings. However, the issue before the court at this stage of the findings is not whether juror number 7 misunderstood the terms, it is whether she gave an incorrect answer. For purposes of question 74, the court finds that her incorrect response was false. Juror number 7 was not biased against the petitioner. Having found that juror number 7's failure to disclose the incident involving Ms. Kinsey, the civil lawsuit against Ms. Kinsey, and the incident involving her hitting Mr. Whiteside constitutes misconduct, the court turns to the next issue. Has the presumption of prejudice based on the finding of misconduct been rebutted? In other words, in reviewing the record as a whole, is there no substantial likelihood that juror number 7 was actually biased against the petitioner? For all the reasons set forth below, the court finds that juror number 7 did not engage in prejudicial misconduct by failing to disclose her prior involvement or the involvement of her family and close friends in legal proceedings. Juror number 7's non-disclosures were honest mistakes. Juror number 7 was a credible witness. Applying the factors set out for the evidence code. Okay, let's go through. Juror number 7 was not impacted by the trauma of having her own unborn child threatened. Okay, we're just going to get on the bold parts here. So they're going to go, like I said, you can read this. Juror number 7 was not a victim of domestic violence. Juror number 7 volunteered undisclosed information to the petitioner's investigator. Juror number 7, December 10, 2020, declaration corroborates her testimony. Okay, let's see. So let's look at this. Juror number 7 hired an attorney to assist her in preparing a declaration for submission with the return filed December 11, 2020. Mr. Zaki, her lawyer, is a criminal defense attorney retained by juror number 7 3 months prior to October 26th of 2020. He had contact with the Stanislaus County District Attorney's Office on the same date. The District Attorney's Office provided Mr. Zaki with copies of the pleadings in the habeas petition. At the time of the initial contact, Mr. Zaki informed the District Attorney that he was not sure whether or not juror number 7 would be providing a declaration for the return. Okay. Financial hardship and the child support forms are inconclusive. And let's see. Juror number 7's reference to little man is not evidence that she prejudged the case. Petitioner also contends juror number 7 made considerable effort at the evidentiary hearing to distance herself from the phrase little man. Juror number 7 testified that she gave Connor the nickname Little Man not during trial but after trial was over and the first interview I did. She did not recall going to the jury room and calling Connor Little Man. Letters juror number 7 sent to the petitioner post-conviction do not show a hidden agenda. What did she do here? During the evidentiary hearing, juror number 7 was asked about letters she wrote to Scott Peterson after the trial concluded. Petitioner contends the letters are material because they demonstrate that juror number 7 was obsessed with Connor and referenced men cheating. Assuming the letters do appropriately reflect juror number 7's state of mind during the jury selection process, the letters do not support the petitioner's theory that juror number 7 wanted to be on the jury to punish him or that juror number 7 was fixated with Connor. At best, the letters demonstrate that juror number 7 was emotionally impacted by her participation in the trial. In her letter dated December 3, 2005, juror number 7 writes, "The jury is going to get together on the 16th of December just for support. Scott, I just want you to know that it is not at all a happy day for us. Each one of us felt like we were just struck by a Mack truck." She described the trial as an emotional roller coaster. In another letter dated December 17, 2005, juror number 7 admits that she had a breakdown. She writes, "I never knew how much this trial had an impact on me. Plus, I have never had a great life. All the pressure just hit me. I think it has been that time of year, our verdict, Lacey and Connor. An emotional reaction to evidence presented at a criminal trial is very different from a premeditated bias at the outset. If juror number 7 did have a hidden agenda and mindset to punish the petitioner, the letters do not reveal one." On October 8th of 2005, juror number 7 tells the petitioner, "I want you to know, whether it means anything to you or not, that I do not hate you. I hate what you did. I know that you and a lot of others say we were all full of hate, but you are all so wrong. The verdict was not based on hate or emotions." On December 3rd of 2005, juror number 7 writes, "Believe it or not, I look forward in hearing from you also." At one point, juror number 7 talks to the petitioner about enrolling in school and passing her final. She tells the petitioner that she has thought about writing her own book about the trial, but promised she would do nothing without his consent. "I am not out to get you or make shite any worse for you as it already is. Please believe me when I say that." Juror number 7 also added her concern about the petitioner's reaction when she publicly spoke out about the trial, writing, "I hope you're not mad at me." All told, the letters do not support the finding of someone with a vengeful state of mind. Petitioner also asserts the letters show an obsession with Connor and suggests that juror number 7's continued post-trial focus on Lacey's unborn child, is consistent with a juror who has been impacted by the trauma of having her own unborn baby threatened. It is true, juror number 7 references Connor and uses the phrase little man in her letters. Equally true, however, is that in those same letters, juror number 7 expressed sadness for Lacey's mother and family, and for petitioner. Furthermore, in none of the letters does juror number 7 reveal that at one time or another the life of her own unborn child was threatened. At best, the letters demonstrate that juror number 7 was sad about what had happened to Lacey, Connor, and their families, and was someone who was seeking to have the petitioner come to peace with his actions. "I will continue to pray for Lacey, Connor, and the rest of the family, as well as you. I hope one day before you pass, you will finally set their souls free. I think of you and how you are doing, Scott. I just can't help it, but constantly think why. Why was that your only option? I keep praying for them and you, Scott. Finally, petitioner suggests the letters are evidence of juror number 7's state of mind about cheating. In her February 15, 2006 letter, juror number 7 asked the petitioner, one other reason I really wanted to write you is, this is for my sake, nothing really to do with the trial, really. You're a man, I want to know. Why do you meet, I think she means why do men cheat? Take, of course, you and Lacey. She was cute, beautiful, full of life, love for you, spunky, happy, just to be who she was and who she fell in love with. So why cheat? I'm asking because the man I was with for 5 years had the same problem. So from a man's point of view, why? Or why do you think? I'm sure there are some that don't believe that. I do believe you can cheat and still love the one you're with. So will you help me? I really do pray for you at these times, Scott. Juror number 7 testified that her question about cheating was about men in general and why they cheat, as opposed to asking the petitioner why he cheated. Again, these statements in her letters demonstrate that her state of mind was not one of vindictiveness against the petitioner, but more of a general inquiry based on the experience that she had and went through with Mr. Whiteside. In any event, at the time of jury selection, juror number 7 and Mr. Whiteside were together despite his ongoing infidelity. The issue of cheating was raised only briefly. Okay, let's see. Taken as a whole, the letters demonstrate a person who suffered a long-term adverse effects from the graphic evidence presented at trial, which was summarized in detail by the California Supreme Court. The evidence included the intact body of Connor that had washed up on the shore and the later discovered body of Lacey Peterson, which due to decomposition had no head, no arms, and one leg. On the day the jury was sent into deliberations, petitioner's own defense counsel described Connor's autopsy pictures as one of the most disturbing pictures they will see. The letter also evidence of a juror, the letters also evidence a juror who, despite all she heard and saw, was trying to get the petitioner to come to peace with what he did and the impact it had on his life and the life of Lacey's family. The letters do not demonstrate a state of mind or contrivance or hatred to support a conclusion that, at the time juror number 7 filled out the questionnaire, her goal was to lie, to sit on the jury, and punish the petitioner. For all these reasons, the court finds that juror number 7's letters, either by themselves or viewed against the entire record evidence, fail to demonstrate prejudice or actual bias on the part of juror number 7. Okay. For all the foregoing reasons, the petition for right of habeas corpus is denied. The clerk is ordered to serve a copy of this order upon the petitioner, Scott Lee Peterson, upon Shelley Sandusky, Adrias Farkas, okay, all those people, okay, and then it's signed, and Christine Masulo. So that's it, and now, like they said, they've got to do something, a new habeas petition, not to appeal this, they can't appeal this, but to show that there's new evidence, which, good luck with that. So, that's that. And let me just check in with, our Jen on the car here. Let me see if she has anything new on that. Okay, so again, if you saw the videos that Jen posted of the car last night, and then she went there live with us, I cut that out of the video and I put it in its own video, but she just messaged me, said the news was all there this morning. I think she says, I think there's a typo, but I think she's going to go there shortly and hopes it's not so busy. And then she said, so that yellow parking pass that I took the film of, and I'll show it again now. Someone sent me that there is a Lakewood Suites in Moscow, Idaho, the Lakita Inn, and there's also a Candlewood Suites in Moscow. So let's take a look at that. Which one is it? Where the parking? Oh, yeah, I've got the video that we just made. Okay, let me grab that video. Okay.
I'm still in shock over last night. Honestly, I'm just, yeah.
Oh, Janie's already working on it, Shayna? Yeah, I saw that she said, yeah, she's already, yeah, she's got to. She can't lose that support, you know. Would not have caused much if you agree, Robity Bob. Hi. But I'm going to just show that she's saying that there's something connected to that parking pass. So let me just get that, the video I just cut up.
Hi, Robity Boop.
You don't see Jen or Jeff in the chat, right? Do you? I haven't
I am
even
going
checked my
to the
email.
chat. Slacking over here. I'm trying to get up.
No,
Okay.
Carolyn.
Hi.
No.
Haven't seen them
Okay.
No.
yet.
All right. So let me go. I'm going to pull this over here. This is, I cut the video down so it's.
When helping children
so
unites
just
us,
be
we
that.
are
I'll
a
pull this
force to
over.
be reckoned with. Where there is
For questioning, he had bandages wrapped around his arms from being cut, and he's
Okay, let me pull this over.
said that he got injured from work when they took him in. You
Scooter.
know who I'm talking about?
I don't know that I'd heard that.
No.
Although I did hear that Enoch.
That was wrapped up.
I am sold. I'm convinced. Your husband can get you up.
So creepy.
Video reel, she'll show
Man.
us the hair. She's taking us all around the car.
Just wait, chill, everybody. Just calm down, okay? Everything's fine.
That was
This
just
car
like
is
the
a-
But this might be the one.
the lady talking right now, her name's Jordan.
No, her name is Jen.
No.
The other lady.
Oh, the other lady is Jordan. Okay.
Yeah, she lives in Moscow. She's married to a police officer. Just FYI.
Okay, here's
There's
the
also that.
Doesn't
hold on.
who doesn't tell me?
I'm trying to see if I can
I mean,
get
oh,
where's that? Wait,
Even
hold
though
on. Okay, so I don't know how. Okay, this basically says parking permit. How do they know what this is? This could be to anything. I mean,
bug him and bug him
wait,
and bug
Jordan.
him.
Because this writing is from the window right here, and then there's Jordan. That could be 1129 or 129.
Where's that parking pass to it? Do you know where that's?
It is inside, and I don't.
It says something about POW or so. Wait, am I saying?
Parking permit, something wood.
Or does that say 1120 or 120?
Oh, wood.
What?
Now she said something about Westwood. What'd she say?
Woods, maybe.
Does it have a date? It has a date on it?
I thought you said
Well, as good
Lakewood,
as I
Carol.
can see.
No
Not
license.
touching anything.
I don't know where she's seeing the wood thing. See, 120, 1.20. What? What is that? Where did she say Westwood? Why did she say Westwoods? Can she see something under that black that we can't see, maybe?
That's what I was thinking.
See what the chat is saying. It all she didn't. I don't know what. Let me see if she answered me back or if anybody said anything about that. Hold on. Let me see if Jeff has emailed me anything. Jeff was in the earlier video. Let's see. talking with the woman. Okay. Jeffrey. Okay, let me see. I don't see anything. And she might be on her way there. Like, I don't know if she's there because she messaged me right before I went live. She just read my thing. Okay. You can only see part of it. I don't want to touch anything. Remember, it was at 2 a.m. this morning. I'm about to head down there. You want me to tell her to come on the live?
Yeah.
Carolyn, yes. I couldn't find my unmute button fast enough. Yeah.
If she can.
Well, let me give her the new thing, right? Because it's a new. Hold on, let me. Copy. That can't be her already, right? No. I didn't give her the... That's Christy. I just gave her the number, so... We'll see.
Gotcha.
Hi, Sherry. Hi, Gianna. Bobbity Bob, Captain Lee fan. Let me see who's here. To Scooter, hello. Bridget, hello. Deborah Vancouverden, Gianna Marie, Jeanette, Kevin Leonard, Chris Ree, LMNW, Nicole, Nightbot, Bobbity Bob, Sherry M, Captain Lee fan. Welcome, everybody. Well, we'll see what happens.
Did she say she's going now?
She said she's going now. Mm-hmm.
Oh, okay.
Yep. Let's see what she said. She said, yeah, she's going to log on and go. She said, I'm seeing the violent crimes unit down processing the car, and it's supposed to be impounding it. That's what another local said. I saw pictures. Also, I wasn't aware that one of the girls was born here in Eugene, Oregon. Madison was. I will log on. It'll be a few minutes as I need to take my dog out. Maybe we should start another live for this. We'll stay in the Zoom. She'll be the same Zoom number, but because otherwise it'll be like all intertwined with the Peterson thing. Okay, guys, so I'm going to end this live and I'm going to start another one up. You know what? Let me make the thumbnail, and that way I can redirect you all so you don't get lost.
Yeah.
Stay
Don't move,
right
guys. Just
there.
Put on your seatbelts. Enjoy the ride. We'll
Yes.
get there shortly.
Yeah, stay right there.
Don't forget to like this video on your way out, though, okay?
Keep your hands and feet inside the moving vehicle
Yeah,
at
I'll
all
just
times.
go ahead and make a new thing, and then she's going to be a few minutes anyway, so if you have to take a potty break, you can go now.
Now is the time. We're not going to make another stop before we get there.
Okay. I will. Okay. I'm just gonna save this. Download. Okay. Let me just set up the new live.
Carolyn,
Yep.
Shanna 360 is asking if you'll be doing an upcoming stream for the 20th anniversary of Lacey and Connor.
Well, I don't know that it'll be on the 24th, but maybe soon. Why would you like that, Shanna? Would you like to speak on that? And let me know. You can email me.
What, keep doing the readings?
No, she wanted let me put the email in chat, Shanna, okay?
I want to read the judge's decision, but it's so many
I
pages
just put
long.
it.
I
Oh,
don't think
thanks,
I can do it
BBC.
that long.
Well, they'll maybe post twice, but that's okay.
Next witness.
Next witness. That was Nicole. That was me. Because I have a little bit of I'm getting over the cold and I can do it good now.
The words. Next witness.
Next witness. Oh, that was good.
I'm so happy he didn't get a trial.
Me too. Oh my gosh, I'm so glad he didn't get a trial. No,
Yeah.
there's absolutely nobody else who had any reason to want her gone, period.
Absolutely.
And
Sharon.
it says that she will participate if you do.
Awesome.
Okay.
But, yeah, send Carolyn an email. That would be wonderful, Shanna. Thank you.
Robbie Bob's asking, where can I get the judge's letter?
I'll put it right in here. Hang on.
Awesome.
I'll put it in the live stream now. I'm going to redirect us, and then I'll put it in this live stream, and I'll put it in the video description. Because I'll read it too later on, and when I have time. Maybe we'll read it on at night or something. So much stuff going on right now.
Okay. Sustained, Carolyn. Sustained.
Okay, here's the letter.
Sustained.
Ruling, I mean. I'm going to put it in the description now, and I'm going to redirect us.
Sounds more and more like Gollum from Lord of the Rings as time goes on. Yes.
Okay, it's also in the description. Save, and I'm going to go redirect us, and then I'm going to close this out, and we're going to go to live with her. Okay, so we'll see you guys in the next one. Love you, bye. Let's see. Let me end this. Okay.